result, along with other election materials under security and accompanied by candidates or their polling agents, were available to such persons as may prescribed by the first respondent. The first respondent has, by paragraph 30 of the regulations and guidelines quoted above, introduced electronic transmission to a collation system in addition to the physical transfer of the election results to the registration area reward collation officer. As stated earlier, the technological device prescribed by ANIC in the conduct of the 2023 election is the bimodal voter accreditation system. The functions of BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or her fingerprints or face, that's facial recognition, thus accrediting the voter to vote at the election. And storing the data and number of such accredited voters. By paragraph 38, Roman 2 and 3 of the regulations, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC8A to the ANIC result viewing portal, after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area reward collation center. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit result and upload same to the result viewing portal RF, there is nothing in the regulation to show that the BVAS was meant to be used to electronically transmit or transfer the results of the polling unit direct to the collection system. It should be noted that ANIC results viewing portal RF is not a collection system. Thus, the Supreme Court in Oyetola and ANIC has explained the difference between the collection system and RF, where again JSC held as follows. As their names depict, the collection system and the ANIC result viewing portal are part of the election process and play particular roles in that process. The collection system is made of the centers where results are collected at various stages of the election. So, the polling unit's results transmitted to the collection system provides the relevant collection officer the means to verify a polling unit result as the need arises for the purpose of collection. The result transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results at the election day, close of court. A community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of election 2022, and the ANIC Manual for Election Officials 2023 show that the Electoral Act expressly provides in Section 621 that after recording an announcement of the result, the presiding official shall deliver same along with election materials under security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines, as well as the ANIC Manual, also state that hard copies of election results shall be used for collation, and it is only where such hard copies of the election results exist. No such hard copy of the election results exists, that electronically transmitted results or results from the ANIC will be used to collect the results. I had earlier said that the non-compliance that can significantly affect the result of an election must be such that it's substantial enough to cause the court to invalidate it as prescribed by Section 135 of the Electoral Act. The burden and standard of proof is primarily on the petitioners to establish the existence of those facts or allegations or such. It's important to note here that although election petitions are sui generis, they are governed by the Evidence Act as well. Where therefore an election petition is founded on allegations of non-compliance, as in the instant case, from the myriad of decisions, the onus is directly on the petitioners not only to establish such through credible and compelling evidence, they have to go further and demonstrate through credible evidence that the non-compliance was substantial and that the non-compliance truly affected the results of the election to warrant their being annulled. See Akinlade and another versus ANIC, Audu and ANIC, Oke versus Mimiko, Kente and Ishaku, Nda Kene and Adamu and others. The Electoral Act made provision for declaration of results and the posting of results of the election. This is Section 66 and 68 of the Act, which have been produced in this judgment. By the law, results are declared by the counting of votes cast in the election and in accordance with the constitutional provision for the election of the President as in Section 133 and 134 of the Constitution. The votes so counted and collected are the votes cast at the polling units. Let me underline here that the conduct of an election, in the conduct of an election, certain processes must have been worked over to conclude and confirm that the election was conclusive. The steps outlined by the law must not be broken. These steps are accreditation, conduct of polls, counting of votes, collation and announcements of results, signing of result forms, and publication of results. The results sought by the reliefs sought by the petitioners are declaratory in nature. It is cited a law that where a petitioner seeks declaratory reliefs, the burden is on him to establish his claim. His success is on the strength of his own case and not on the weakness of the defense of the respondents or defendants. See, Missionary and Arebeshola and Oga versus Piazzo. It is also the law that the pleading and the claim of the petitioners determines the burden and the standard of proof that is required. By Section 135 of the Evidence Act 2011, if the commission of a crime by a party to any proceeding is directly an issue in any proceeding, civil or criminal, it must be proved beyond reasonable doubt. See the application of this provision in the cases of PDP and IG versus PDP and others, APC and another versus Obaseki and others, Suleiman and others versus APC and others. In all these cases, the position of our law is that whenever crime is alleged, even if the case is a civil case, its proof must be that of beyond reasonable doubt. In the instant case, the petitioners have grounds of non-compliance with the Electoral Act 2022 and allegation of corrupt practices. Section 134(1)(b) refers to the ground of corrupt practice or non-compliance. If the ground pursued in any petition is simply non-compliance with the Act and there is no tincture of allegation of crime, the proof required would be on the balance of probabilities. But the standard of proof in any ground that is primarily on corrupt practices would require proof beyond reasonable doubt that allegation being criminal in nature. In the instant case and on the issues being resolved here, the petitioners tendered some documentary evidence directly from the bar. The objections to the admissibility of most of the documents had earlier been dealt with by this court in the earlier ruling on the objections as to the admissibility of the documents, and some of them have been held inadmissible in evidence. The petitioners called 2 star witnesses alongside other witnesses. The star witnesses are PW19, Dr. Alex Adum Tar, and PW22, Senator Dino Melai. The sworn evidence on oath of PW19 is at pages 131